The Appellate Division First Department is now in session. Good afternoon and welcome to the Appellate Division First Department's virtual oral argument. I will now call the calendar. People versus Moreno, submitted. United Probation versus the City of New York. Is the appellant present?
Good afternoon, Your Honor. Yes, Erica Healy-Kagan of the Curlin Group on behalf of the appellant.
Okay, so you have 5 and 1.
Thank you.
Is the respondent present? I have a feeling your microphone is muted. Is the respondent present?
Yeah, so sorry. Yes,
Okay.
Julie Steiner for the respondent city.
So you have 4 minutes.
Thank you, Your Honor.
Matter of Michaelia J. is submitted. Santini versus Gillian Abrams Designs, submitted. People versus Pugmire, submitted. People versus Zosia, submitted. And Shanudin versus Carde, submitted. Gomez versus Drew, submitted. PPR Media versus Leo Cable. Is the appellant present?
Yes, Your Honor. Jonathan Montcalm, New York Counsel on behalf of the appellants. I would also like to request that our time be split up 5 and 2.
Okay, so you have 5 and 2.
And to introduce Counsel Gregory Tamkin, who will be arguing the appeal on behalf of appellants.
So noted. So granted. Is the respondent present?
Yes, David Douglas, New York Counsel for the respondent.
So you have 10 minutes.
And I'd also likewise like to introduce and ask that Mark Cahill, who's been admitted pro hac vice, be allowed to handle the appeal. The argument.
Yes. People versus Allen, submitted. Matter of Kalia C, submitted. Abnet versus Deloitte Consulting. Is the appellant present?
Yes, Your Honor. Mark Ressler for Appellant Abnet.
Okay, so you have 10 minutes. Is the respondent present?
Your Honor, could I split that up 8 and 2?
Yes.
Thank you.
Is the respondent present? Abnet Inc. versus Deloitte Consulting. Is the respondent present?
We are, Your
Yes,
Honor.
Your Honor.
My partner, John Hartman, will address the argument. Sorry, go ahead, John.
You have 8 minutes.
Thank you.
People versus Jackson, submitted. Bridges versus Security Resources, submitted. Alonzo versus Reed Elsevier. Is the appellant present?
Yes, Your Honor.
Is
Russell
that Mr.
Tishman.
Mr. Tishman, you have 5 minutes.
May I
Please.
split that 4 and 1, please?
Yes. Is Mr. Pizzuto present?
Yes, Your Honor, present for the Reed defendants and Vision Counsel.
Okay, so you have 5 minutes. And then that leaves us with Mr. Zhu.
Yes, present, Your Honor, for plaintiff.
You have 5 minutes too. So it's 4 and 1, 5 and 5.
Thank you.
People versus Castillo, submitted. FWAT versus New York City Department of Finance, submitted. People versus Schulterbrand, submitted. English versus Board of Trustees, submitted. Benjamin versus Department of Housing. Is the appellant present?
Yes, Charles Small, attorney for the appellant.
You have 5 and 2. Is the respondent present?
Yes, Eva Jerome for HVD.
You have 5 minutes.
Thank you.
I remind the attorneys to keep their microphones muted until their case is called for argument. I also remind the attorneys to avoid talking over the justices when the justices are speaking This is a traditional rule of the court, and it's even more important when we're doing video conferencing. United Probation versus City of New York. The appellant may proceed.
Thank you, Your Honor. May it please the court, my name is Erica Healy-Kagan of the Curlin Group, and we represent the appellant in this matter, the United Probation Officers Association. Our client represents the city's probation officers who are seeking to obtain the requested payroll records in this matter as part of their effort in conjunction with other labor unions to remedy longstanding pay disparities.
Are you asking, this is Judge Friedman, I have a question. Are you asking the respondents to, in effect, create new records? The materials that you're seeking do not as such exist. Isn't that so?
No, Your Honor, and this has actually been litigated in a number of other related matters in the Supreme Court. In the CWA Local 1180 matter, which is cited in the papers, there's also been a recent decision of Justice Hagler in the matter of FDNY Local 2507 versus City of New York. That's index number 160063 of 2017. In both of those matters, respondents have attempted to argue that a new record would be created by responding to this request. In both matters, a detailed evidentiary hearing was held, and the judge in both matters was Justice Hagler, and he found both times that based on the evidence presented, that the new record argument would be overruled, that these are all records that are maintained in electronic databases that are maintained by the city, and therefore under the Freedom of Information Law, a simple computer manipulation is all that's required.
Counsel, this is Judge Kern. Why isn't there an affidavit as to how the city could provide this information without creating a new record? Because you referred to an evidentiary hearing, but here the city has provided an affidavit, and your side has not provided any affidavit explaining why a new record would not have to be created.
Yes, Your Honor, and in the lower court, the court here never addressed the merits in that sense. The court only dismissed the petition based on the argument of being duplicative, which we, of course, address in our papers. And at the evidentiary hearings in the other related matters, the petitioners in that matter put expert witnesses on the stand in both cases, who the judge felt was more credible than Ms. Bryan, who the city, submitted their affidavit. In this case, from the prior cases, again, once the testimony of both witnesses were, expert witnesses were compared in related matters, the court found that there was no such new record argument that was
Counsel, weren't you required, though, this is Judge Kern, weren't you required to put forth an affidavit in connection with the motion to justify the need for hearing? I know that the court below didn't reach that, but it's nowhere part of the record. And why would we even order that a hearing be held when no such affidavit was ever submitted?
Well, Your Honor, under the Freedom of Information Law, the burden is squarely on the respondent to make a showing that the exceptions that they're trying to take advantage of are acceptable. And in the court below, we had argued that based on the affidavit that was presented, there is not sufficient proof to show that the new record argument was valid. And therefore, if that issue, if Judge Rackhauer needed further information about that, or felt that there was an issue on the merits to be resolved, we of course could have presented a witness, but we never got to that because, as we explained in the papers, the court in essence over-extrapolated and held that.
Excuse me, counsel, this is Justice Weber, but they did make the argument, did they not, that it was overly burdensome? So in response to that argument, would you then not have submitted an affidavit as to the fact that, one, that it was not overly burdensome, and also, two, that it was not the creation of new records?
Your Honor, again, in the lower court, we made the argument that respondents had failed to meet their burden of showing either burdensomeness or new record. There's also case law Your Honor, that clearly shows that any sort of burdensomeness argument is not supposed to be taken as a reason to not produce a FOIL request. There's cost shifting that can be applied if there is, a large amount of time that's required. But
no, I understand that. But my question is, why would you not submit an affidavit or something in support of your argument? One, that it was not overly burdensome, and also two, that they would not require the creation of new documents.
Understood. Yes, and we didn't submit an affidavit, Your Honor, but we did submit the case law, which we believe is clear that as a matter of law, this is not a new record and this is not burdensome. And even if there were some amount of time required to pull these records, which in Ms. Bryan's affidavit, she even, what she has firsthand knowledge about is just a small amount of time.
So your position is that as a matter of law, it would not be cumbersome. It would not require them to actually create new records? I don't understand. How could that be as a matter of law?
Well, based on the evidence that the respondents have submitted, the affidavit of Jody Bryan, she admits that these records are maintained in a computer database and that with some amount of manipulating of that computer database, these records can and are regularly produced. So under the Freedom of Information Law.
You're past your time. I will ask, do any of my colleagues have any further questions? Thank you. The respondent may proceed.
Good afternoon, Your Honors. Julie Steiner for the City of New York. First, the Supreme Court correctly concluded as to the Department of Probation and the Police Department requests that those were time barred as having been essentially duplicative of the prior request that was done in 2017. With respect to the records for ACS and Department of Correction employees, Your Honors are correct that this would be the creation of a new record. The affidavit of the analyst from DCAS, Jody Bryan, she has extensive knowledge in the computer, in quantitative data analysis. She was familiar with the relevant databases, and she explained that for these 34,000 current and former employees, it would require at least 98 hours of new programming, new code, which this court in NICOSH in 2010, which Your Honor, Justice Friedman was on the panel for, explained that there's two different types of creation of new records. If it's just a simple manipulation of the computer, like maybe an Excel spreadsheet where you might delete a column, that will not be considered a new record. However, as the court explained, if it's the creating of new software or new code, that would be the creation of a new record. And she in detail explained the steps that would be necessary to get these records or get this data, which actually exists in 3 different databases, one of which is not even maintained by DCAS. So of the 158 hours that she explained in detail would be required to create this record, 98 of which is new programming and new code. And that is clearly within the realm of the creation of a new record, which FOIL does not require. In addition, these records, as we explained below, would be an invasion of personal privacy, given that it would release the gender and the race of these individuals. And again, that's an invasion of personal privacy that this court should not countenance, given that this information was voluntarily disclosed to the city on the guise of voluntariness. And regardless of what their noble purpose might be, the weighing of the equities in this matter requires that this information remain
Counsel, this
confidential.
is Justice Moulton.
Yes.
Sorry to interrupt you. What's your best case on this privacy assertion that you're making? Is there a case that says that that's private information?
It is essentially private information. The Committee on Open Government, in fact, has said that information has absolutely nothing to do with the performance of a public employee's job. So for that reason alone, it must remain and should remain private. To allow someone's gender information or race information, which has no bearing on their work, to be released would be to put them at a disadvantage. I mean, generally speaking, race and gender can be used negatively against someone in the employment field. So it should
Any case
remain.
that says that.
Offhand, I do not, Your Honor. If you would like, I can send a letter to the court after the fact with a case if I have one, or if you prefer.
Well, the record's closed as usual. I mean, you can ask
Yes,
Justice Friedman
I understand that. But that aside, the biggest issue.
If we decide we want that, we'll let you know.
I appreciate that, Your Honor. The biggest issue, though, as this court has recognized, is that it is a creation of a new record. The city did not rely on the overly burdensome argument. We relied on the exception being that this is a creation of a new record. This is not a simple manipulation of a computer. It cannot be done with ease.
Thank you. Thank you. Do any of my colleagues have any further questions? Thank you.
Thank you.
The appellant, you have 1 minute in reply.
Thank you. I'll just quickly, thank you, Your Honor. I'll just quickly note regarding the any question of privacy issues in both of the related matters. Justice Hagler required the names to be redacted, which under FOIL is the appropriate way of resolving any sort of concern about personal identifying information.
Wouldn't cross-referencing, if all these records were turned over, wouldn't cross-referencing permit disclosure of who the people were, even if there is redaction on as to this?
No, Your Honor. And again, in the detailed evidentiary hearings where both parties submitted expert testimony, it showed that that concern of respondents was merely speculative. The FOIL case law also shows that speculation in that sense should not be held to be an appropriate objection. The merging of lists only really works if lists are highly curated. When we're looking at public records and public data, open source data, this is not, especially with large data sets like the ones here, it's not a reasonable speculation to think that data sets can be merged. And just lastly, I'll state that the last hearing that Justice Hagler had on a related matter, he specifically addressed this question of the multiple databases. And he said that this argument of 3 databases where different information needs to come from is respondents playing what he called a shell game. DCAS, which is one of the respondents here, is basically human resources for the city. And if they don't have this public record and this demographic information, that is a failure on their part to properly maintain their employees' records. Our clients, as I said, are trying to investigate and remedy pay disparities, and therefore this information is crucial, and it's public records which multiple courts have held need to be produced, regardless of the same objections that were raised in this case being raised in those. Thank you very much.
Any of my colleagues have any further questions? Thank you. Thank you both.
Thank you.
PPR Media versus Leo Cable. The appellant may proceed.
Good afternoon, Your Honors. My name is Greg Tamkin, and along with Jonathan Montcalm, I represent the appellants. We're here to answer a simple question. Can a dismissal without prejudice finally resolve anything? That's how we got here. The motion court answered the question that it could. A dismissal without prejudice, however, did not finally resolve either the underlying dispute or it did not finally resolve.
But the case that you are seeking indemnification for, it's a different case. It's not even all of the same parties. The Centro Ortological claim involves mostly different parties than was involved in the Castillo action.
Your Honor,
I mean, this agreement reflected such a requirement that the notice be given before July 15th, 2016. Sorry, to July 30th, 2016, of an action.
That's right, Your Honor.
At that point, the action is over. When it's a new action that starts. How do you get past that?
Really easy, Your Honor. The question is, what are we seeking indemnification for? And that's what the agreement speaks to. Section 10.2 of the agreement gives the right to indemnification. You have a right to indemnification and for a breach of a representation or warranty. In this case, that original class action that was filed gave rise to a claim for losses. Those losses were up to $17 million worth of damages that were going to be sustained by the cable subscribers who were choice cable customers. Those cable customers claimed that they were charged an illegal billing fee. And the claim for indemnification and the claim notice that nobody disputes wasn't timely. Everybody agrees that claim notice was timely.
Counsel, this is Judge Kern. This is Judge Kern. You refer to breaches of warranties and representations, but doesn't the stock purchase agreement specifically require that an action actually be pending when a claims notice is filed, which was not satisfied in this case?
I respectfully disagree, Your Honor. When the claim notice was filed, an action was in fact pending. That action was pending, and it continues to be pending. There's a claims of 2 individuals who were choice customers, as well as a putative class action. Those same 2 individuals and the putative class that they represent simply refiled their case later. And so what we have here is an interpretation of a contract that creates a situation where, because the claim was dismissed without prejudice and then refiled by the exact same individuals and the exact same putative class, only dropping other putative classes and other putative class members that don't matter, that weren't choice customers to begin with. With that dismissal without prejudice, the claim of those individuals is in fact still pending. And again, we need to focus on what is
Counsel, isn't the import of what you're saying, this is Justice Moulton, I'm sorry to interrupt you, that an action is still pending even after it's been dismissed without prejudice? Is that what you're saying?
I'm saying the action of those individuals is still pending.
No, but action is also a defined term, is it not?
Action is very broad in this case. It is a defined term. It's losses, it's a claim, it's things before government.
A claim, action, lawsuit, proceeding pending before or issued by any governmental authority.
Right.
So
here you have Ms. Morales filed a claim. She filed a claim in San Juan, Puerto Rico. She dismissed that claim without prejudice, refiled that exact claim in Mayagüez, Puerto Rico, and that claim is still pending. But the keys, Your Honor, is not just whether the claim is pending. The key is whether the claim is finally resolved. That's what we're here to talk about. That's what the specific language of Section 10.01 talks about. Is that claim finally resolved? What is a claim? A claim is not the action. A claim is the claim for indemnification, a claim for the losses. And what the court did in this case is the court imported procedure as to how you make a claim notice and what is required by a claim notice into the substance of what is a claim. And that's very important.
Counsel, though, is finally resolved in a defined term in the contract?
Finally resolved is not a defined term in the contract, but I know what finally resolved is. I think this court knows what finally resolved is. There has to be some resolution, and that resolution has to be final. When the words aren't defined, you can look to dictionary definitions, you can look to common parlance. So we know 2 things are not finally resolved here. Number 1, the claim for indemnification. The claim that was sent says there was a paper billing fee. That paper billing fee, people were being charged for getting a piece of paper with their bill on it. That paper billing fee was allegedly illegal. Has that claim for the illegality, the breach of the representation and warranty, that conduct was illegal, has that claim been resolved? The answer is unequivocally no. Why? Because the only chance that could have been resolved finally was through the case through the underlying claim. That claim, that action, also has not.
So what you're, this is Judge Friedman again. So what you're telling us is that action pending and claim pending are one and the same.
I don't think they're necessarily one and the same, but that in this case, the claim relates to the claim for indemnification. The action is what gives rise to a loss. And those are different. The claim here, and as set forth in the claim notice, which I encourage your honors to look at, that claim notice actually sets forward the claim is for a breach of a representation and warranty, 6.15, and those losses.
You again. I'm sorry, it's Justice Moulton. When would this claim go stale then?
This claim would go stale at the final resolution of that action, the settlement of that action, or whenever, in fact, that claim is decided. For example,
what if that new action is brought instead of the new action having been brought, I believe it was in August, had it been brought a year afterwards?
If it originally was brought a year afterwards, that would not meet the expectation of the parties. In fact, the claim was brought in time. If that claim would have first been brought yesterday,
no, but then it's discontinued. It's discontinued without prejudice, and then there's a new action started after the July 30th, 2016 date. The action is started, I believe it's in August of 2016. What if the action had been discontinued as the action was here without prejudice, and then this subsequent action was brought in 2017 involving the same claim? Why would that be covered by what you're telling us?
It would be covered. The statute of limitations hasn't expired. That's the point of a dismissal without prejudice.
Although the contract here specifically says the point is to shorten the statute of limitations that would otherwise have been applicable. It's not a statute of limitations test.
It shortens the time by which one can provide notice of a claim, and the notice was provided on June 23rd of 2015, maybe 16, June 23rd of 2016. That notice was provided of a breach of a representation and warranty.
You're past your time. Do any of my colleagues have any further questions? The respondent may proceed.
Thank you, Your Honor. May it please the court, my name is Mark Cahill from Piltwell & Stewart in Boston, and together with David Douglas, we represent PPR Media LLC. I'd like to make one point of law and one quick point of undisputed fact. The point of law is that New York law generally disfavors indemnification agreements, and particularly in the context where we have here, where those agreements or the agreement at issue was drafted by sophisticated business entities represented by sophisticated counsel. Courts apply a very strict interpretation to them and will only find a duty to indemnify if the intent to indemnification is unmistakable. Here, that legal standard hasn't been met. To the contrary, this agreement specifically...
Because on the facts, the appellant on the facts has an attractive argument. It's discontinued without prejudice. You know this is not over. The same claim is started really just about a month later, involving some of the same people. So you would think you're on notice, you were given notice originally, and you know that this is not over.
Respectfully, Your Honor, it's not the same claim. It's not the same plaintiffs. There are differences between the two actions, and the parties have stipulated to that fact. That's not, the parties agree that those are distinct and separate actions. What the appellant is trying to conflate here, and it did this at the trial court, and it's doing it again today, is the distinction between a claim for indemnification for losses that might arise from a third-party lawsuit, which in this case originally was the Castillo lawsuit, versus a direct claim for indemnification by the buyer against the seller for breach of a rep and warranty. The original claim notice here does not make a claim for breach of a representation or warranty. It makes a claim for losses that might be sustained as a result of the third-party action. And it says specifically that the third-party action gives rise to the possibility of a breach of a representation and warranty. If the appellant thought that there was a breach or even a potential breach and wanted to preserve its right to seek indemnification separate and apart from the existence of a third-party action, it could and should have done so by making a direct claim under section 10.06C. It did not do that. I don't know why, presumably because it also was engaged in the same type of paper billing practice that was alleged to be illegal in the Castillo action. But it didn't do it, and so therefore its only route to potential indemnification was through the existence of the Castillo action. That action no longer exists. It ended when it was voluntarily dismissed, and that action has never been resurrected, and we have a totally separate action. I think everybody, including Appellant, would agree that if the Centro Otological case had been brought when it was, or even if it had been brought on July 1st of 2016, the day after the bar date, which respectfully, Your Honor, I think you earlier mentioned it to be July 30th. It's really June
30th. June 30th.
2016. Everybody agrees that if the claim had been brought the following day, it would be barred. And the appellant might think that that's an unfair outcome, but that's an outcome that the parties, the very sophisticated parties, in this case, bargained for. Indemnification arrangements are risk-shifting allocation arrangements. And in this particular indemnification agreement, more so than many that courts have to rule upon, the types of claims, the nature of claims, and the limitations that apply to those claims are very specific. And here they made, at their own election, a claim for a third-party indemnification based on the existence of a certain lawsuit, a certain action that no longer exists. And once that case went away, their indemnification claim based upon that case is moot. The existence of the Centro case or any other case that might have been filed or may in the future be filed with respect to the underlying question of whether paper billing practices are a violation of Puerto Rico law, it would never be covered under this arrangement. Because otherwise, as I think, and I don't want to wrongly attribute, I think as Judge Moulton was referring to, you would have an open-ended risk of indemnification, and the funds that the parties in good faith deposit into escrow, in this case, some $7.5 million remaining to be released, would be withheld indefinitely. And that's certainly not what commercial parties generally intend, and that's absolutely not what the commercial parties in this case intended.
Do any of my colleagues have any further questions? Thank you. The appellant has 2 minutes.
Thank you, Your Honors. I want to pick up where opposing counsel left off, which is that this is an open-ended risk of indemnification. And that's just not accurate because, in fact, the agreement is very clear. The only thing that gets open-ended, and that there will always be open-ended, is claims that are made prior to June 30th. Here, there was a claim made for illegal conduct. That illegal conduct claim made was going to exist for 1 year, 1 month, or 20 years until that issue was resolved. That's what the parties specifically bargained for in Section 10.01. They made it clear that until that claim is finally resolved, as long as you made it, there is going to be indemnification. And that's what we have here. The claim was made. Now, opposing counsel notes that this is a problem because it doesn't meet the expectation of sophisticated parties. These parties were sophisticated and they absolutely understood what they were doing. And in this case, they made claims relate to a breach. Now, Mr. Cahill notes that in this case, the claim was not a direct claim, but a third-party claim. That's because a direct claim cannot be submitted once a third-party claim exists. So in this case, there had to be a claim for under a third-party notice. That claim was provided, but the claim itself is a claim for the illegal paper billing fee. And the court needs to focus.
Just to go back to your first point that you could raise a claim 20 years hence, doesn't that completely run athwart the express purpose of this provision? Which is that The applicable claims deadline, I'm quoting, is intended to shorten the period otherwise provided by law during which claims for breach of representations, etc., may be made under this article.
Your Honor, that's a good point. I may have misspoke. It's not that claims can be raised at any point in time. Claims can be raised for a year, but can be resolved at any time. In this case, the claim was raised. There was an illegal paper billing fee. If that claim is resolved negatively at any point in time, that's what the parties bargained for. One doesn't import procedure with respect to whether there's an action and whether an action gives rise to a claim. Claims arise as a result of losses. And in this case, those losses of $17 million are clearly claimed in the claim notice because the claim notice relates to losses for a breach of representation and warranty that has not been resolved. Finally or otherwise, it hasn't been resolved. That claim still exists.
Do any of my colleagues have any further questions? Thank you both. Avnet versus Deloitte. The appellant may proceed.
Thank you, Your Honor. Mark Ressler on behalf of Avnet. I'd like to focus primarily today on why the trial court should not have deprived Avnet of its right to pursue a claim against Deloitte Consulting for fraudulent inducement of the settlement agreement and release. The trial court's ruling in that regard, an incorrect ruling, was based on three aspects of the settlement agreement and release at issue. Number one, the release itself. Number two, a merger, integration, and no reliance provision. And number three, as the court said, the combination of the release and those provisions. In so doing, the trial court ignored a fatal defect in Deloitte's release, what we call in our papers the gap period. The release was executed, signed on September 7th, 2016, but its effective date was August 1st, 2016. That means there was a 37-day period during which a Deloitte statement, omission, or representation would not be covered by the release. The reason why that gap period is so important is because it knocks out two of the three bases of Her Honor's ruling below. Because of the gap period, the release falls by the wayside, and the combination of the release and the integration clause fall by the wayside. So what's left of Her Honor's ruling is what this panel needs to address, namely the scope of the merger provision and non-reliance provision at issue. The touchstone that courts always use when determining whether an integration clause will preclude a claim for fraudulent inducement is the degree of specificity in that merger clause. That's the rule that was announced initially in the seminal case of Sabo v. Denman 60 years ago, and it's guided litigants ever since. In other words, if the merger provision is general, boilerplate, then the fraudulent inducement case can proceed. If, on the other hand, the merger provision explicitly references and addresses the subject matter, the representations that form the basis of the plaintiff's fraudulent inducement claim, then the fraudulent inducement claim will be barred. We submit that the merger provision here is quintessentially a general boilerplate merger provision. Let me focus the court's attention on the Denine Realty line of cases, the case in which the merger provision was specific. That case involved a real estate transaction. The merger provision literally said that the buyer had inspected the premises and was accepting the property as is. Quote, the seller has not made and does not make any representations as to the physical condition, rents, leases, expenses, operation, or any other matter or thing affecting or related to the aforesaid premises. Based on that degree of specificity, the court barred the fraudulent inducement case in Denine. Our case could not be more different than Denine because the merger provision here contains no such specifics. It would be one thing if Deloitte's merger provision said that Avnet has inspected the software system at issue as is. It'd be one thing if Deloitte's merger provision said that representations concerning the state of the SAP system at issue were disclaimed, that representations concerning the ability of the Deloitte team to fix the system were disclaimed, or if the fixability itself of the software system were disclaimed. But again, we have
This is Judge Kern. I'm looking at the release, and it's an extremely broad release, and it uses the language, all matters with respect to the project evolve. That's extremely comprehensive. Wouldn't that subsume anything having to do with the ability to fix the project, of anything of that nature? Why wouldn't that be covered by that extremely broad language?
Your Honor, again, as I said earlier, because of this gap period, the gap between the signing of the release, now I'm just talking about the release, because of the difference between the signing date and the effective date, the release is out of the picture. There's a 37-day window during which omissions and representations by Deloitte are not protected by the release, which is why I'm only focusing on the merger provision. And we submit that that's the only part of the settlement agreement that matters in this analysis.
So, Judge Friedman, is it your point that there were oral representations in this gap period which fraudulently induced you to enter into this?
That's correct, Your Honor.
So how could there be justifiable reliance on this at this point? I mean, you're obviously in a contentious relationship with them. You're getting to the point of actually releasing claims. You're justifiably relying on their representations at that point, as dealing with sophisticated parties?
Your Honor, 2 points, at least 2 points. Number one, issues of justifiable reliance are almost always issues of fact, not to be decided at the pleading stage. Number two, in terms of sophistication, Deloitte goes to great lengths in its papers talking about the sophistication of the parties. First of all, sophisticated parties are fraudulently induced all the time. That's not a bar. But number two, the sophistication here resided squarely on Deloitte's side, because Deloitte—
But you're fraudulently induced at a period of time that you know that you're already in a fight with them.
But Your Honor, Deloitte is an expert in SAP software. It holds itself out as the preeminent SAP software implementation firm in the world. And during this period of time, when there were problems with the SAP system, Deloitte assured Avnet that those problems were minor, that the system was fundamentally sound, and that Deloitte's team had the ability to fix those problems. We specifically make those allegations in paragraph 44 and 45 of the complaint, among other places. And because of the gap period, those allegations are not covered. Those statements by Deloitte are not covered by the release. So Deloitte's other argument is the differentiating factor here is that there's also a no reliance provision. Deloitte says the combination of a no reliance provision plus a merger agreement puts this case in the denon line. In other words, the fraudulent inducement claim cannot proceed. That is absolutely not the law. Deloitte cites no case. There is no case ever in which any court in this state has held there's any difference between a non-reliance provision on the one hand and a merger provision on the other. They're the same thing. It's an artificial distinction. The concept of non-reliance is necessarily baked into the concept of a merger clause, because a merger clause says all prior representations are merged into this agreement. And similarly, a non-reliance clause disclaims reliance on any prior representation. So Deloitte's primary argument as to why this case falls outside the SABO rule is just completely wrong. One case I would commend to Your Honor's attention, we love the case because it's a software case, is the superior technical case against Lawson Software. In that case, the court permitted the fraudulent inducement claim to continue because, as here, it was a general boilerplate release. The court said that concerning this transaction, a software licensing agreement, that had the software company inserted into the merger clause that the plaintiff was disclaiming reliance on representations concerning RPG code and pay-to-bill functionality, technical software issues, then the fraudulent inducement claim would be in the SABO line of cases, and it would have to be barred.
Counsel, I'm going to interrupt you for a second. You keep saying a general boilerplate provision, which it does not seem to me to be, but is your argument that the provision had to say something specifically like we are not relying on any representations that you could fix, evolve, like something specific of that nature? Is that what your argument is?
Yes, Justice Kern, that's precisely right. That's what the Sabo and the Denon cases both stand for the proposition.
Why isn't that covered by the very broad language that we are resolving all issues? Why wouldn't that encompass issues such as your ability to fix it? I mean, clearly at that point, there's a real issue about their ability to fix it, which is why you're entering into the settlement agreement.
Because, Justice Kern, under New York case law for 60 years, what Your Honor just described as broad language, that's the problem. It's broad language. It's not specific. Her Honor below correctly noted.
Counsel, I'm sorry to interrupt, but to Judge Kern's point, how do you grapple with Citibank versus Plappinger?
We embrace Citibank v. Plappinger, Justice Moulton. And the reason for that is because in that case, there was specific language that went right to the subject matter of the fraudulent representation claim. Citibank v. Plappinger and all of the cases that interpret it specifically say we are not disturbing the Sabo rule. Sabo stands. Deloitte.
But they also said that the explicit disclaimer in Danon wasn't necessary. It wasn't, the disclaimer in Plappinger was not as specific. It didn't deal with a particular transaction, but it was very general, as Judge Kern's point.
But it was not general to the extent that the merger provision here is general. The merger provision here goes on for half a page, as Her Honor below said, but it doesn't reference the specific representations it needed to reference. Again, Deloitte, a sophisticated party when it comes to being sued for botched software implementations, this is not Deloitte's first rodeo, knows how to write a bespoke merger provision. It could have inserted in the merger provision a clause that said, Avnet is disclaiming any representations made concerning the state.
The other side of that is that you're not an unsophisticated party either, and you know that there were problems and that there were problems with Deloitte. Anyhow, do any of my colleagues have any further questions? You have time in response. Let's hear from the respondent.
Good afternoon, Your Honors. This is John Hartman from Kirkland & Ellis, and we represent the respondent, Deloitte Consulting. This is an unusual case in that all but one of counsel's arguments on appeal and Avnet's on our appeal are flatly contradicted by plain provisions in the parties' agreements, either the settlement agreement or the MSA. And the only argument they make that is not, which relates to the post-settlement fraud claim, is flatly contradicted by the allegations of the complaint. I want to briefly just follow up on Justice Kern's remarks and say that the broad release provision, and I don't think we need to read that again to you, but the broad release provision in this contract and in the settlement agreement was designed to settle the dispute. We thought we'd settled this case. We did settle this case. And it plainly covers and releases and waives all of the claims that they had, both known and unknown, fraud otherwise, in existence as of the effective date of the release, which is August 1st.
Well, let me turn your attention to something else. Of course, if you want to come back to this, I'm sure you will and you can. Why shouldn't the actual fraud claim post the release be allowed to stand?
Because of the non-reliance provision. So to be clear, we are not claiming that the release released claims based on future conduct that post-dated the release. We're not claiming that. I don't think we could. That would be a very difficult argument for my client to make. But that claim and whatever.
So there is a breach. Supreme Court allowed a breach of contract claim post-release to stand. So why shouldn't the plaintiff also have a post-release fraud cause of action? The fraud cause of action is not, or if you say it is, tell us why, is not duplicative of the breach of contract cause of action. Aren't they making separate allegations that they would have dismissed you fair? The breach of contract is loss for your failure to correct the problem, but the fraud is they would have gotten rid of you sooner. And there may be limitations, which we don't know at this stage of the case, how it'll play out. There may be limitations on their contractual damages, which there wouldn't be on their fraud damages.
If I may, there are two post-effective date fraud claims going on. One is you fraudulently induced us to enter into the settlement agreement, and I very much want to get back to that and address that claim. The other is, wholly apart from the settlement agreement, you committed fraud post-settlement in connection with our work after the settlement agreement.
That's the one I'm asking you about.
Right. That, Your Honor, is exactly the same as the breach of contract claim. If you look at the operative allegations in the complaint with respect to the facts upon which that claim rests and the damages that claim seeks, they are the mirror image of the post-settlement agreement contract claim that the trial court allowed to stand.
Counsel, Judge Kern, isn't there a distinction, though, in that there are at least alleged contractual limitations on the damage claim, on the contract claim, which potentially would not be present on the fraud claim, which is what would potentially allow the fraud claim to go forward as not duplicative?
The New York law with respect to a duplicative fraud claim says that it is duplicative and can and should be dismissed if it arises from the same facts and if it essentially alleges and seeks the same damages. It doesn't turn on whether there are limitations baked into the contract on the contract claim. The law says that, and here, if you look at the operative allegations in their complaint, they are entirely duplicative, Your Honor. Okay? Now, I do want to address the fraudulent inducement with respect to the settlement agreement, because that's important and that's the focus. There's a non-reliance provision in the settlement agreement. And the non-reliance provision says that in negotiating and in executing this agreement, we have not relied on any extra contractual statements that you've made. They made that promise in the agreement. And the point that we make is that's in addition to a merger clause that's in the agreement, and they're not the same. A merger clause says this is our agreement. It's our entire agreement. There are no other agreements. This is it. The non-reliance clause says we didn't rely on anything you said in deciding to execute this agreement. That's the representation and the promise they made here. And that's a distinction that the Dinan court made when it talked about the Sabo case and the Sabo line of cases. It is not accurate to say, as Mr. Ressler did, that they're not distinguished. The Dinan case itself drew that distinction. It said, were we only dealing with a merger clause here, Sabo would control. The Dinan court said that, but it said we're not. In addition to that merger provision, we've got a non-reliance provision, and that non-reliance provision takes us out of the Sabo line of cases. And New York courts, in a number of cases that we cite since Dinan, have enforced these non-reliance provisions, particularly when we're dealing with a party that is sophisticated and that plainly knew what it was doing. And we know that because Avnet said so in the contract. In the provision that we're dealing with, they said, we've read it, we've looked at it with our attorneys, we understand it, and we're doing this voluntarily. And in that context, New York courts are crystal clear that they will enforce a non-reliance provision against a sophisticated party like this. And if you don't enforce it, then the finality of settlements goes out the window. The ability to know that you settled a case goes out the window, because sophisticated parties can always come up with a representation or a theory that is not specifically addressed in the contract, potentially. And on that point, it is not the case, and it is certainly no longer the case, that the non-reliance provision has to be clairvoyant in the sense that it has to predict the precise theory of the fraudulent inducement claim that comes 3 years later. And I think that's true for 3 reasons. One is it ignores much of the rationale of the Danan case, which did focus on the fact that the party there could not be said to have misunderstood the contract or not to have read it and not understood what it was doing. Justice Moulton cited the Plappinger Citibank case. That case made explicit at the Court of Appeal level that in New York, you don't need, particularly when you have sophisticated parties and a multi-million-dollar settlement agreement, you don't need specificity and you don't need the non-reliance provision to predict the precise theory that may come out of the blue 2 or 3 years later. And finally, if you look at the cases that the New York courts, including this court, have decided since the Citibank and Plappinger case, it is clear that they don't require specificity, particularly in the circumstances of where you have a sophisticated party. And I'd like to make one last point in my remaining time, and that goes to several of the questions of the panel, which is, by August, they plainly knew, and they plainly were no longer in a position to justifiably rely. The trial court said explicitly in a ruling, Avnet knew the problems with the system. Avnet knew what it was doing when it entered into the broad release and the non-reliance provision. And you know that from the complaint where they say within days the problems arose. Within weeks, there were customer complaints, significant complaints about the performance of the system. By midsummer, they had spent, I think, $2 million to try to investigate the problems and get to the bottom of the situation. And then they negotiate and enter into an $8 million settlement. Against those undisputed facts taken from the complaint and from the contracts, you cannot conclude that they justifiably relied. One last point. They got the benefit of their bargain. The deal was, we give you $8 million of potential value on discounted future work in exchange for a release, complete peace and finality with respect to these claims as to who's at fault for the system's problems that we all know of to date. They got the benefit of that. We kept working for them for 7 months at those discounted rates to the tune of $4.5 million. That too is in the pleadings. They got the benefit of their deal. Now they want to take away the benefit of our deal, the bargain that we struck and what we should get. And that would be very improper under the circumstances. That is not a decision and a signal that would be consistent with New York law or good under New York law.
Thank you. Do any of my colleagues have any further questions? The appellant in reply.
Thank you, Your Honor. With respect to Plappinger, contrary and respectfully to counsel's comment that the specific provision in the merger clause wasn't the animating factor in that case, this is a quote from Plappinger. Quote, "Here we do not have the generalized boilerplate exclusion referred to by the commentators. Rather, we have an express stipulation that defendants were not relying on a separate oral agreement to fund an additional multi-million-dollar line of credit. There's no such specific disclaimer in our merger provision or our no reliance provision. None. Second point, Justice Friedman, you perfectly articulated why the trial court erroneously dismissed the post-settlement agreement fraud claim. It is absolutely different from the breach of contract claim, the latter of which focuses on technical mistakes by Deloitte in terms of its coding and its project management. But the fraud claim post-settlement focuses on Deloitte's misrepresentations concerning the soundness of the system to continue to have Avnet pay it fees. And the damages are absolutely different because the damages cap applies to the breach of contract claim, but doesn't apply to the fraud claim. And of course, the fraud claim is seeking rescission. There's a case right on point in our papers that says when a fraud claim seeks rescission, it can't be duplicative of the breach of contract claim. With respect to a non-reliance clause being somehow different from a merger clause, I urge the panel to read the Katz case. It's in our papers. It's a Southern District of New York case, but it absolutely says there's no distinction between a non-reliance clause and a merger clause. The reason why Denon was decided the way it was decided was because of the specific nature of the merger clause. Quote, and this is from Denon, the Sabo case dealt with the usual merger clause. The present case includes a disclaimer as to specific representations. And finally, Your Honors, counsel notes that the finality of settlement agreements are important. I urge the panel not to let the fact that this contract is a settlement agreement be the driving force. Settlement agreements are to be treated just like any other contract. Settlement agreements can be fraudulently induced. This party, Deloitte, knew how to write a bespoke, tailored merger provision that would have addressed the specific representations. You don't have to be clairvoyant to know that if Avnet was going to file a claim for fraudulent inducement of the settlement agreement, it would be because of Deloitte's representations concerning the soundness of the software system at issue. And the $2 million that Avnet paid before the settlement agreement went right into Deloitte's pocket, and it was paid solely because Avnet was relying on Deloitte's statements that we got this, don't worry, our team has the ability to fix these problems, which, by the way, are not that serious because the system we designed and built and made $60 million designing and building is fundamentally sound.
Do any of my colleagues have any further questions? Thank you both.
Thank you, Your Honor.
Alonso versus Reed Elsevier. The appellant, Mr. Tishman, may proceed.
Thank you, Your Honor. May it please the court. In the short time that I have, I'm not going to be able to address all of the issues raised in our brief, so I respectfully refer you to the brief. But here we're dealing with some very simple, undisputed facts that entitled Freeman to summary judgment. On March 17, 2010, under Freeman's supervision, 6 customer care assembly units were installed at the Javits Center, all of which were to support monitors. All 6 stood overnight. 5 stood supporting the monitors throughout the show, as this design had done previously and subsequently. And the one that did not stand fell when a Javits Center electrician performing an exclusive service.
Wasn't the work order given to you? Wasn't the work order given to Freeman? Didn't it have stabilizing feet? And isn't there evidence that the tower was not, the tower that was actually built and fell over was not delivered with that component?
Your Honor, there is a discrepancy. There's a photograph showing what are actually flower stands. They're not designed as stabilizing feet. They're hollow stands, but the renderings that were given to Reed, which are in the record, show that that wasn't there. But the case law in the First Department and elsewhere is clear that the issue is not whether this can be the safest possible design, but simply whether it's safe. And with respect to that,
but Friedman was this is Justice Weber. I'm sorry. Friedman was to design, construct, and fabricate the tower. So on your motion, was it then? Did you not bear the burden of showing that there was that the tower was sufficiently designed and that there was no problem with the design, as Justice Friedman just mentioned, in terms of its falling over? I mean, was there anything in the record to sustain your burden?
Yes, Your Honor, there are several things. There's testimony that this design adequately supports monitors and did so at this show, at prior shows, and subsequent shows. There's testimony that there's nothing in the record to indicate that the design itself is insufficient, and the fact that it supported the monitors elsewhere, and that it was standing without any issue until the Javits electrician was mounting the monitor, and the monitor fell and hit Mr. Alonso, we think establishes the adequacy of the design.
But I thought there was an issue as to the weight as well as to the height, and that because of the additional weight, that is what allegedly caused it to tip over. And I thought it was your witness's testimony actually admitted that there was no evidence that any consideration was given as to the effect of any additional weight.
Your Honor, our witness, Mr. McGuire, was not part of the design team. What he testified was that this had been field tested and used, and in fact, it was field tested. It was used at this show. This is one of 6, the only one where there was a problem, and the only time there was a problem was when the monitor was being installed, and the record is undisputed that the monitor was not installed properly. Mr. Isaiah from NMR, who provided the monitor, testified that if the monitor was installed correctly, that the bracket would not separate. In fact, photographs show that the bracket separated. What was mounted by the electricians to the tower stayed on the tower, but the monitor itself fell off.
Do any of my colleagues have any further questions? Thank you. Mr. Pizzuto?
Thank you, Your Honors. As in my client Reed and Vision Counsel's capacity as respondents in this case, where summary judgment was granted to my clients on the contractual indemnity claim against Freeman, it's our position that the lower court properly granted summary judgment. The contract is clear that the indemnity is owed for anything arising out of Freeman's performance of the services for my client. This is clearly something that arose out of Freeman's performance of services, as it was Freeman's designed and constructed tower that fell on top of the plaintiff's head. In opposition, Freeman essentially raises 2 arguments. One, that we did not properly plead contractual indemnity in the pleading. It's our position that the word indemnity does encompass contractual indemnity, but even if it doesn't, this court has been clear that
you didn't as such put in a cross claim, isn't that so? Even though your complaint does speak about it, but you didn't make a separate cross claim, is that correct?
No, there's a cross claim for indemnity, Your Honor. It just omitted the word contractual indemnity, so I think the position was that can only mean a common law indemnity claim. Our position is indemnity means indemnity, whether it be contractual or common law. But even if it's accepted that it needed to be pled as contractual, this court has held the Weinstock case, 254 82nd 165, First Department 1998. Summary judgment may be awarded on an unpleaded cause of action if the proof supports such cause of action and if the opposing party has not been misled to its prejudice. Freeman, from the outset of this case with the pleadings, knew we were seeking indemnity from Freeman.
Well, Freeman is also claiming that you failed to timely notify or give notice to them of the lawsuit, of the claim.
That's correct, Justice Weber. That's their second argument, that there wasn't timely notice, and their obligation to defend my client was somehow frustrated by that. The problem is Freeman was not agreeing to defend both my client and NYCCOC, who my client owed indemnity to. So it was impossible to accept Freeman's acceptance of our tender. They were not going to protect our interests correctly. And there was no frustration of the defense, because Freeman's defense all along has been an NYCCOC mechanic knocked this thing down as he was trying to put up the monitor. That defense has been Freeman's defense from the outset. As the lower court held, they zealously pursued that defense. So there's been no frustration of that defense. And the contract doesn't bar indemnity if there's a frustration of defense. Also, another thing to consider, Justice Weber, is the actual time frame to bring an indemnity cause of action under contract has not even started running yet. It only starts to run when plaintiff recovers a judgment against my clients, and that's a 6-year statute of limitations. As to my client's position as an appellant in this case, there was a motion for leave to amend to add a workers' compensation bar defense. The proof shows the plaintiff was sent there by a temp agency, but he was there to get instruction from Reed employees as a greeter as to what he was going to do, where he was going to be stationed, and how he was going to greet people. It is our position that the lower court really kind of put in a summary judgment standard for the amendment of the pleading when it really is just, is there a cause of action that is devoid of merit? And under the evidence, I think in the record, it's not devoid of merit. In addition, the lower court simply, in my view, and I think it's clear in the decision, did not address at all Reed's motion for summary judgment separate and apart from the workers' comp defense, just Reed's motion for summary judgment or Vision Counsel's motion for summary judgment, that as a mere licensee, Reed as a mere licensee of the premises does not have the requisite possessory interest under the case law to be held to have a duty to the plaintiff. And for that, I would cite the court again to a First Department case, Gibbs versus the Port Authority, 1783rd 252, First Department 2005, and actually a Supreme Court case, Stern versus DMG World Media, 2013, New York Slip Op 33404. The lower court simply did not address those arguments whatsoever. Once it decided the workers' comp argument, it seemed to have skipped over and did not address the arguments that neither Reed nor Vision Counsel had any possessory interest in the premises to have any duty to the plaintiff. Separate and apart from that, even if it's assumed that there was a duty running from my clients, the Vision Counsel and Reed, to the plaintiff, there's absolutely no evidence of negligence on the part of either of those clients, Reed or the Vision Counsel. The record is clear that this was a booth that was designed by Freeman, constructed by Freeman. My clients only had input into the aesthetics of the booth, the color of the booth, what the literature on the booth was going to say, what the monitor might say when it was on. And the cases are clear that simply reviewing work for aesthetic purposes does not create negligence. This was a sudden instance where this thing fell. There were no complaints that it was teetering or unbalanced that went to anybody. It was a sudden instance that it fell. There was no notice to my clients, and they did not cause or create the condition. Plaintiff in opposition, their main opposition to that portion of the motion is where they argue that my client's contract with NYCCOC has a provision where Reed says it would assume responsibility for all the acts of its contractors, here Freeman being one of them. My argument is that that is a contract between my client and NYCCOC. It does not create a separate and distinct duty to the plaintiff where Reed is a licensee and Vision Counsel has no possessory interest whatsoever. And there's a case on point there as well, which is we believe the Grelicki's case, 9083rd 480 First Department 2011.
Do any of my colleagues have any further questions? Thank you. Mr. Zhu?
May it please the court, Michael Zhu on behalf of the plaintiff respondent William Alonzo, appellate counsel to Losner Mastro Pietro. The trial court, and I'll work backwards because I believe that we'll deal with the easier issue with the workers' comp and Reed's claim that it was entitled to amend.
So why isn't plaintiff a special employee of Reed? CTI is after all a staffing agency, isn't it?
Well, the problem for Reed is in support of its motion for summary judgment, there was virtually no testimony from any Reed witness establishing how the plaintiff was to be supervised. The only testimony, and which was highlighted by the trial court with respect to supervision, was plaintiff's testimony, where he said that he would come in the morning, he met his supervisor, Sheryl. Sheryl told everybody to meet downstairs. They went downstairs. And as soon as he was talking to Nancy, another coworker, the entire tower collapses on him. So outside of that, there's no testimony from any witness that has any personal knowledge establishing CTI giving up control over its employees and Reed assuming control.
Well, didn't Grant, who is the vice president of operations for Reed, testify that someone from Reed would meet with CTI people and train them?
It did, But the problem there is there's no follow-up to that. You can't just come out and say, yeah, we would have done this and we would have done that when there's no evidence establishing that any of that would have happened.
Wasn't there similar testimony from Judy Weaver, also a Reed employee, that she would meet with CTI people and train them?
I'm not sure where that is as part of the record. I don't recall any of that.
I think it's page 779 through page 781.
In any event, even assuming that, there's an issue of fact here because the plaintiff testified that he wasn't given instructions by anyone other than Sheryl on the morning of the accident, and that it happened prior to anything else, any other functions that he would have performed as a greeter.
But this is Justice Weber. There was an affidavit from Vision Counsel stating that Vision Counsel didn't play any role in the construction or installation or responsibility, etc. What about that?
So then we're dealing with the liability issues now outside of the workers' comp?
Yes, in terms of liability issue. I apologize.
Okay. Well, as far as plaintiff's concerned, we treat Reed and Vision Counsel as the same. Reed has a contract with NYCCOC as a licensee to use the space to set up exhibitions, and Reed contracted with Freeman and other contractors to set this up. To the extent that the court's going to dismiss the case against Vision, there's really not much that we can say here other than there was a joint venture between Vision and Reed, and so you can't let Reed out. So if you can't let Reed out, even if you let Vision out, Reed is still in the case as a party, as a director.
Aren't the real defendants that belong in the case Freeman Expositions and Reed Exhibitions? Aren't those really the parties with potential liability here? I mean, you've got a lot of other entities named, but aren't those the entities that really belong, that should remain in the case?
Judge Freeman, I don't have a problem letting them out as long as Reed and Freeman are still in, whether they're called, whether it's called Reed Exhibitions or any other corporate entity. There's a contract that was signed by Reed with NYCCOC. There was a contract between Reed and Freeman. One of the corporate entities is liable here. As far as the plaintiffs are concerned, we really wouldn't care one way or the other whether one particular Reed defendant was let out over another and another was kept in. With respect to Reed's argument that it didn't owe a duty to the plaintiff, as defense counsel conceded, there was a contractual provision where Reed expressly promised to be responsible for all acts and omissions of contractors and subcontractors and vendors, including Freeman. If the contractual obligation is upheld here, that helps the plaintiff in establishing that it owed a duty, because there was also testimony that Reed was supervising and controlling the work provided by Freeman based on its submission of they provided specifications and drawings to Freeman, asking them to build these exhibits. They provided photos of exemplars of what they wanted and what they needed. And the Reed deponent, Michael Grant, testified that as operations lead, that he would routinely inspect the work that was performed by Freeman. So under these circumstances, we believe that Reed can be held vicariously liable for the negligence acts of Freeman.
Do any of my colleagues have any further questions for Mr. Zhu? Thank you. Mr. Tishman, go ahead.
Thank you, Your Honor. With respect to Justice Weber's point, the Freeman-Reed contract in terms of indemnification, Mr. Pizzuto is arguing that it should be parsed. First, there's no claim. That was a strategic decision as to no contractual indemnification claim. If the court were to compare the claim brought by Reed against NMR, who it subsequently let out. There's a common law indemnification claim. There's a contractual indemnification claim. They know how to plead a contractual indemnification claim if they want to. They didn't. In terms of the provision, paragraph 28B1 afforded Freeman rights. It had the right to a prompt notice, not a cross claim. It had the right to control Reed's defense with counsel of its choice, which would have resulted in no cross claims by Reed had they tendered in a timely fashion. They waited 4.5 years. And during that 4.5 years, among other things, they denied, they didn't assume the defense of NYCCOC, who they're claiming now they were contractually obligated to do. So if they had that obligation, they breached it. But we have an unappealed ruling from below that, in fact, they didn't have that obligation because the court found that denying NYCCOC's motion for summary judgment, that a fair reading of the record could support a finding that NYCCOC was solely negligent. That's the work of the electricians. So this case falls directly within the federal court's Hammond decision, where Freeman, when there was a 4.5-year late tender, even having been denied the opportunity to defend Reed from the outset, agreed to take over Reed's defense. But Reed wouldn't let them do so because, as Mr. Pizzuto claims, Reed allegedly owed indemnification and defense that it didn't provide to NYCCOC. But the court below finds that, at least at this juncture, they didn't defend that. So we've got a mirror image acceptance. And on that basis, the case law is that any obligations under the contract for indemnity were vitiated. On top of that, Reed abandoned its claims against NMR, although there's a mirror image contract that entitles Reed to indemnification and insurance from NMR for claims arising from its activities, the same standard as in the Freeman contract. And there's no dispute here that the bracket that separated was provided by NMR and the monitor that fell belonged to NMR. So we have a failure to mitigate as far as the indemnity claim. On the liability claim, I wasn't able to address before. The court below rejected rejected the argument that plaintiff could not rely on res ipsa loquitur. And we believe that was error for 2 reasons. First, given the court's holding that the record could support a finding that NYCCOC was solely liable, the first element, that the action couldn't have occurred in the absence of negligence, which the First Department in Braun said meant the negligence of the specific defendant, and that it was essentially.
Even if we reject res ipsa loquitur, it doesn't mean you prevail on this.
I understand that. There's still the issue of whether there's direct evidence, and with respect to the absence of direct evidence, which was demonstrated, the fact that the design supported the monitor at every other location shows that this is not a design defect. The fact that this stood
you claim that's established as a matter of law and that there's no issue of fact about that.
I claim that it's established as a matter of undisputed fact because
and therefore as a matter of law, and that there is no issue of fact. Do any of my colleagues have any further questions? Okay, thank you all.
Thank you.
Benjamin versus Department of Housing. The appellant may proceed.
Good Good afternoon. My name is Charles Small. I'm the attorney for the appellant Sheryl Benjamin. This is a family member succession rights claim for a Mitchell Lammer apartment. The appellant, Sheryl Benjamin, she's a senior citizen, so all she had to establish was that she resided with her son, who was the tenant shareholder, for at least 1 year, immediately before the son permanently vacated the apartment. So the way I see it, the issue...
So when do you say, what year is it that you say she resided with her son in the apartment?
She resided in this apartment from approximately December 2010 until her son moved out in September of 2012, based upon his non-resident tax return, where he filed a part-year return with the account.
Is that the case you made in front of HPD?
I did not represent her in front of HPD.
Well,
she was pro se. That was one of the problems. This lady didn't know what she was doing. She didn't submit anything.
Who lived where and when is not, that's a matter of fact. I mean, she knew when she lived there, and she knew when her son lived there.
She did, but she never expressed herself. If you look at her application for family member succession rights, it was a one-page application. It appears on page 162 of the record. Just as an example, she signed this application in December of 2016. And she clearly indicates, they ask her, how many years did you live in the apartment? She writes 6 years. And an earlier question, I ask her, when did you move in? She writes May 2014.
And she also writes that Lionel permanently vacated in June 2015.
Exactly. I'm telling you, she had no idea what she was doing.
The income affidavits list Lionel for 2015 and 2016, list her as living there. But then we know that there is other evidence that had Lionel living in Maryland years before.
No, Lionel had a part-time job. I think he's a green superintendent in a golf course in Maryland, but that it was part-time, and then it became permanent, and then he buys a house and he moves out. I believe he moved out.
HPD finds that Lionel primarily resided in Maryland beginning in 2013.
Right. So the thing is, this was just decided on papers. There wasn't an actual hearing.
I'm sorry, counsel. This is Justice Weber. Is it that she did not know what she was doing, or that she submitted conflicting information? Because I do see at some point there are conflicts in terms of when Lionel was in the residence, when he vacated, when she moved in. There are income affidavits as to Maryland. There's documents that she submitted as to voter registration. There's IRS documents, 1099s. And I do see at some point in time, there was, I don't want to say an advisory opinion by HPD, but there seems to be some a point in time where HPD attempts to assist her in terms of stating exactly what documentation is necessary and what documentation should be considered. And she appears to still submit, again, conflicting information.
That's absolutely correct. They set forth what she was required to do, but she spoke to different people. First at the housing complex, they told her one thing. She'd speak to another person, they told her something else. The lady was lost. She didn't submit anything. I mean, when she came to me and I tried to open it up, I submitted her jury duty, proof that she served on jury duty in 2012. There's a letter from Congressman Charles Rangel addressed to her at the subject premises, and that letter is dated January 10, 2011. Her father died. That's why Congressman Rangel wrote to her. The father died in January of 2011. I submitted her 1099 IRS form for year 2011. We submitted Citibank credit card statements dating back to as early as December 2010, I believe. Chase Bank statements, Verizon telephone bills, all of this stuff she never produced.
Okay, do any of my colleagues?
It's all done on papers, excuse me.
Do any of my colleagues have any further questions? Okay, thank you. The respondent.
Good afternoon. This is Eva Jerome from the New York City Law Department on behalf of HPD. I would like to first address this claim that Ms. Benjamin didn't know what she was doing. There's evidence in the record of her being listed as being at 2 different apartments. If you turn to the record in page 189 is a letter showing that from 2016 from the IRS showing both apartment 17E, which is the subject apartment, and I believe apartment 9K. If you bear with me, if you turn to page R171, that's a mid-May 2017 denial by the housing company of her succession rights. Curiously, May 31st of 2017, she has notarized a statement saying that as far back as 2010, she relinquished all of her shares to that apartment that was listed on the IRS document. So the timing is very interesting that she, after being denied succession rights by the housing company, would take it upon herself to write a note saying I've surrendered all of my shares.
So Appellant's position has 2 major infirmities. One, they're trying to upset the administrative finding upon evidence submitted after the administrative proceedings have taken place, which were not part of the administrative record. But secondly, even when you consider those documents, there's serious discrepancies in the claims being made by the petitioner. Is that correct?
That's correct. Even if this court were to consider or to remand the evidence, she hired the attorney, that all she has mustered and attached. There are no income affidavits for 2011 and 2012. There are no tax returns for Ms. Benjamin for 2011 or 2012. No driver's license of Mr. Benjamin, Lionel Benjamin. And neither Lionel nor Ms. Benjamin have the certified New York City resident income.
So, counsel, this is Justice Weber. So, I want to say you just stated what is lacking. So, my question is kind of a follow up to Justice Friedman's question, and that is, the question is, based upon what was submitted by counsel post administrative review, would those documents that were submitted by counsel be sufficient to establish succession rights to the apartment?
No, Your Honor. Even looking at what was submitted, they do not meet the standard for qualifying for succession rights. And you were correct earlier when you said even her papers post-administrative determination offer conflicting dates even within her own affidavit for certain events of moving in or him moving out. There's no proof of her primary residency in the documents attached to her petition for that period that she now says is the relevant period. And of course, this court, we submit that the court should not look outside the record, especially since, as you stated, she was given the letter that explained you can have a lawyer, that this is very important, These documents are examples of those that you might want to submit. This is about your home, and that the only recourse afterwards is to commence an Article 78 proceeding. It was always her burden to establish 1 year during which both she and Mr. Benjamin resided there as their primary residences, and then have her listed also on the income affidavits, and she has not satisfied her burden with respect to that at all.
Do any of my colleagues have any further questions? Thank you. You have 2 minutes in response.
Okay, the fact that she referred to another apartment on the 9th floor that was her daughter's apartment that she lived in just for a short time. It's strictly a red herring. What I'm asking for, in the interest of justice, that the Appellate Division remand this matter back to HPD to reopen the hearing or for a new hearing where she can present the requisite evidence and testimony, to have line a little bit there to show that there was co-residency for the 1 year period. It can be shown. Definitely in the record, she did not produce it, but she did live with the son for the requisite 1 year period immediately before he permanently vacated, and she is entitled to family member succession rights.
Any of my colleagues have any further questions? Thank you. Thank you both.
Thank you very much.
Thank you.
This concludes oral arguments for today. Court is adjourned.